Good morning, everyone. Our esteemed guest speaker, Professor Dr. Anirban Majumdar, Dr. Tia Subramanya, our Honorable Dean, Dr. V.J. Praneshwaran, Director, Professors and fellow students. On behalf of CMR University, Karnataka State Council for Science and Technology, Intellectual Property Cell, I, Harshita Raj, fifth year student of BBLLB, welcome you all to the webinar on Demystifying Author in Evolving Copyright Law. I request all the attendees of this event to kindly mute your audio and turn off your camera unless requested otherwise. Thank you. I request the attendees to post their questions pertaining to the lecture using the chat box, which will be addressed at the end of the lecture. Thank you. Now, I take this privilege to introduce our guest speaker for the day, Dr. Anirban Majumdar, Professor of Law of the West Bengal National University of Juridical Sciences. Sir is a graduate from Calcutta University, has done his LLB from Burdwan University. He has done his LLM from National Law School of India, University Bangalore, and MPhil from National University of Juridical Sciences, Calcutta. He has been awarded PhD by National University of Juridical Sciences, Calcutta. He specializes on intellectual property law and information technology law and offers these subjects both in undergraduate and postgraduate level. He is teaching copyright law, patent law, and information technology law since 2003. He wrote his PhD thesis on copyright protection in databases. Sir is also associated with Max Planck Institute for Intellectual Property, Munich, has been a visiting officer at Toro Law School, New York University, and Cardiff University. He has also been a Segler Scholar at the Tel Aviv University, Israel. He has authored several articles on copyright law in both international and national journals. Moreover, Sir has been part of major research project of UGC as well. He is member of expert committee on utility model constituted by DIPP, Government of India. He is also member of Copyright Enforcement Advisory Council. Sir has been the coordinator of MHRD IPR chair at NUJS during 2014 till 2019. Thank you, sir. It's a privilege to have you today. I now invite Dr. Tia Subramanya, our Honorable Dean, School of Legal Studies, to deliver welcome address.
Yeah. Respected Professor Anirban Majumdar, Praneshwaran, and all the teachers of CMR Law School and dear students. I deem it a great privilege to welcome Sri Anirban Majumdar. I was working in the National Law School, Calcutta, NUJS. At that time, I came to know about Anirban Majumdar. He is such a wonderful person and a brilliant scholar with a wonderful exposure. And he has come here earlier as well and in one of the online programs. And I felt that by inviting such people, you will be strengthening yourself in your knowledge of the intellectual property rights. Sir, on behalf of the university, I welcome you once again.
Thank you, sir.
Yeah. Voice.
Thank you, sir, for your cordial welcome. I now invite our guest speaker of the day to deliver the talk on demystifying author in evolving copyright law. Sir, floor is yours.
Good morning, everyone, and thank you, Professor Subramaniam, for giving me this opportunity. Now, there are two things I like to mention. It's a coincidence, today is birthday of Rabindranath Tagore, and it's a rare opportunity to pay him respect in this way. That we are discussing something which is about authorship, and and the background story is that last week when we had a meeting of UG Council, who takes care of all the plagiarisms of project, I received a project where the Turnitin report was that it's having 20% similarity, but 100% AI generated. So if the project is 100% AI generated, then whom do I evaluate? The AI or the student who has submitted? So that's the time when I thought that the next lecture which I am going to deliver, why can't I discuss about authorship and try to demystify in the context of AI? So and incidentally, it became the birthday of Rabindranath Tagore, the greatest of the author of all time. Let me share the PPT. I believe there will be questions which we will take at the end. Maybe I'll speak for 20-25 minutes and then we'll have an interaction. Okay. Now, as the title suggests that we are going to discuss about authorship and more importantly, what constitutes author. How do you identify author? What is expected from author? When you call someone author? And try to demystify from the legal point of view. And towards the end, we'll address the technological implication in the authorship. Now, as we know that the history of copyright law starts its journey from the Statute of Anne in 1710. And if you read its preamble, it starts with this sentence that it is an act for the encouragement of learning. Now, if you have a law whose objective is to encouragement of learning, then you can understand that in that background of encouragement of learning, author plays a very important role. And actually, it is to offer protection to the author, because authors were exploited by the stationers who were the owner of a printing machine. So, to protect author from the exploitation of the stationers, this Statute of Anne was created, and obviously it says that it is for the encouragement of learning, and it, for the first time, recognizes the legal right of authorship. That is, what are the rights author will enjoy? Because otherwise, before this, author was, in the complete mercy of the people who were the stationers, who had the printing press, who had the authority to print, and they were simply exploiting them. Okay, but although it recognized that author needs a protection, it gave a statutory right of authorship, but it could not develop the jurisprudence of author's right, or jurisprudence that what constitutes author. Now, if you look at the UK Copyright Act, the existing Copyright Act, that is Copyright Design Patent Act 1988, it says author of a work as the person who created it. Okay. Now, when you say that author is the person who creates it, do you think that the author is going to create on his own from the starting from the scratch to the final product, or is going to take help of others? And if it is taking help from others, that how much percentage of help it can take, and even then it can be considered as author. So, what do we mean by creation? We have to discuss and understand. Okay. If you turn towards US copyright law, then it says that author is the person who conceives of the copyrightable expression and fixes it in a tangible medium of expression. Now, that gives us little more detail about what is expected from an author. So, as the description suggests, that he will first conceive the matter, the product, the work which is going to create, and not only he will conceive, he will also fix the expression, and will fix the expression in a tangible medium. That means the author has to conceive the idea of the product, and then it has to express. And when it expresses, it will fix in a tangible medium. Then only you can be called author. If you come to Indian Copyright Act only identifies the author, but it doesn't define what makes someone author. So it says for literary dramatic work, it is the author. For musical work, it is the composer. For artistic work, it is the artist. For photograph, it is the photographer. For cinematograph, film, and sound recording, it is producer. And interestingly, towards the end, it says that in relation to literary, dramatic, musical, artistic work, which is computer generated, the person who causes the work to be created is the author. Fair enough. Now, these are the three different statutory understanding of author, one from the UK, one from US, and one from Indian copyright law. But the question is that how do we start, or how do you describe the essential ingredients or the features of author? Now, author is that person who writes or composes the work. So you expect author to give birth to that work, okay? Either all by himself or according to the direction given by another person. Whenever a copyrightable work is created, author puts in his intellectual ability in order to create the work. So here is one more criteria. That is, author is the person who is going to put his intellectual ability in creating the work. Now, if you put the points together, then author is the person who will conceive the work. Now, after conceiving the work, he will fix it in a tangible expression and expression in a tangible medium. And while doing that, he will put his intellectual ability in creating that work. Okay. So first, he will conceive the work. Second, he will express the work and fix it in a tangible medium. And while doing that, he will put his intellectual ability. Then, let's take few examples. So the person who is translating, will you call him the author? Whether the act of translation will constitute author? Now, if the person is translating by himself manually, then will you consider him to be author? Or if the person is translating with the help of a software, will you call him an author? The person who corrects spelling, will that person be author? The person who corrects punctuation, will be an author? Indirectly suggesting people who had value to your work, will they be also become author? The person who reviews your work, whether the reviewer is author? The person who at the time of reviewing contributes significantly, will also become author? The person who summarizes the work is an author? Now, the person who summarizes manually is an author, or the person who is summarizing with the help of a software is also an author? The person who is updating your work is also an author. So we need to ask this question as you deal with copyright law, as you deal with the subject matter related to copyright, that when an author comes into existence, or what are the contribution you expect so that the person can be called an author. Now, it is not necessary that the author will be someone who will do the entire work on his own. So there can be a possibility that there will be a couple of people or more than one person who will be involving in creating the work. And that's how your concept of work of joint authorship comes into existence. Now, when you try to look at statutorily, work of joint authorship means in Indian law, it is the work which is produced by the collaboration of two or more authors, in which the contribution of one author is not distinct from the contribution of another author or the authors. So look at it now in detail. That is, so in case of work of joint authorship, you expect a work to be created. Now, work to be created by collaboration. Now, then the question is, what do you mean by collaboration? If I take assistance of five people, are they collaborating with me, or are they helping me in doing certain specific work? So, whether all the people who are helping me in creating the work, are they be called collaborator, or there has to be collaboration which has to be fixed beforehand? For example, three of the students, they come together and decide to write a work or write a project or write an article jointly. So there is a sense of collaboration before you start the journey. So the question is that whether the collaboration has to be established, whether the collaboration should, should be there before the journey of the work starts, or what are the proof, or what are the indicators that there exists a collaboration? Number one. Number two, it is a collaboration of two or more authors. So all those who are collaborating, they have to satisfy the definition of author. They have to contribute in such a way that they can be called author, and their contribution should be such that it will not be able to distinguish who has made which part of the contribution. That means, if I consider in this way, that A conceives a story, B makes the draft, C checks the spelling, D corrects punctuation, E looks at overall structure, and then the article is ready. Then whether A, B, C, D, E, all of them to be considered as author, and whether all of them are involved in that collaboration, and whether they should be called joint authorship, is the question. If you look at USA, in the USA, the work concept of joint work is a work prepared by two or more authors with the intention that their contribution be merged into inseparable or interdependent part of a unitary whole. That means, in case of US jurisprudence of joint author, there is an issue of intention. So you need to have an intention that you will be working as joint author, or you will be creating a joint work. That intention is important. Until as that intention of creating a joint work is there, it will be difficult to consider it as a joint work. Not only that, you will have intention, you will be having an intention where the contribution, respective contribution of independent contributor, they will be merged into inseparable or interdependent parts of a unitary whole. That means, when you will make that article, the reader will not be able to understand what has been contributed by A, what has been contributed by B, what has been contributed by C, what has been contributed by D. That cannot be identified because their contribution have been merged into inseparable or interdependent parts of a unitary whole. That means the final product should look like a unitary whole. So the example with which we started, that someone has conceived, someone has made a draft, someone has corrected the spelling, someone has corrected punctuation, in that situation, everyone's contribution is distinct. They are not merged into an inseparable or interdependent parts. So if you distribute your work and divide your work and assign independently, then it will be difficult to conceive as a joint work, because your contribution might be identifiable. They are not merged into an inseparable parts. But without distributing the or assigning the independent contribution, if five people, they come together and they decide that they will be writing an article together, where who has written which part is not identifiable, in that case they can be called joint author or joint work, because there is an unitary whole There is an intention to create, joint work, and they have been merged into an inseparable, interdependent part of an unitary whole. We need to come to India to refer to a very popular case called Najma Heptullah versus Orient Longman. Najma Heptullah versus Orient Longman, many of you who have studied copyright law, I'm sure you are familiar with. It is Maulana Azad's book, India Wins Freedom. Maulana Azad used to orally give his idea, and he used to give his idea in Urdu. And Professor Kabir used to take note of that, used to translate in English, read out the text to Maulana, and thereby, finally, the work is to be created. Professor Kabir, who is also an author because he has specific contribution, definitely not the sole author, but they to be treated as joint author because Maulana Azad gave the oral version of his experience in Urdu. Professor Kabir took note of that, translated in English, will read out the final version, and then the work is to be created. So obviously both of them have contributed and they can be considered as joint author. Professor Kabir had done all the work of translation and editing. Then if you take that example, that who has given the permanent, tangible expression, it is Professor Kabir. And if Professor Kabir has given a permanent tangible expression, then Professor Kabir should be treated as sole author. Whereas Maulana Azad, who has given his idea in Urdu orally, is only giving an idea which is not protected under copyright law. In that case, you can always consider that Professor Kabir is the sole author. But Professor Kabir, in the agreement with Orient Longman, had mentioned to give 50% royalty to the legal heirs of Maulana, which is very clear an indication that he himself did not consider that he was the sole author. Rather, both of them were joint author of the book. So that suggests that irrespective of the distinction of their contribution, irrespective of the relationship or the contractual relationship, whether it is there or not, it is also possible when both of them are very clear that what is their role, and both of them consider that it is a work of joint authorship and voluntarily agrees to give 50% of the royalty. If you go back to the very early case of Walter versus Len, Walter versus Lynn is a case when the concept of originality was not built into the structure of copyright law. What was important is that what is the role of a reporter who writes down in verbatim the speech of another person? Is it possible that you call the reporter to be an author when he is not contributing intellectually, rather he is writing down what has been said by another person? Is it possible that you can find out the attribute of author in the reporter? Is it possible that you identify reporter's labor, which makes him the author? Because the reporter takes the shorthand notes of the speech and takes a verbatim. So the reporter's labor, which is in fixing the speech, will it make him author? Is it possible that you can identify that reporter has given or invested labor, skill, and judgment which is necessary to become an author? Does a reporter who sets out to make a verbatim report of a speech exercises creative choice? Now that's very important. Now, if you listen to a speech and write a report on that, there is no problem in accepting your authorship. But instead of making a report of a speech, if you take note of the speech verbatim, where is that creative choice? And when you correct the punctuation, or when you put the report in the way which is useful or user friendly to the audience, will you be able to say that the reporter has given his personal touch of the where is that creative choice which will make you author? Donahue versus Allied newspaper is another interesting situation. Now, there it says that if a person has a brilliant idea for any story or a play or any literary work, which as per him is original, and if such a play or the story is communicated to any other person who has clothed the work in the form of idea, then it cannot be said that the person who narrated or had an idea shall be the owner of the author, shall be the owner or the author of the book, which was published by the person who clothed it. That means the person who is giving idea is definitely important, but the person who is converting that idea into an expression, making a book, is the person who is the author, not the person who is giving the idea, because idea is not protected under copyright law. It is the expression which is protected. So what becomes important is who is giving expression. But if you try to look at copyright law as an extension of intellectual property law, then you need to always ask the question, who contributed intellectually? So that should become equally important, if not more, a question that rather than the person who has fixed it, who has expressed it in the tangible form. Now, there are two opinions of two authors. One is Goldstein, another is Niemeyer. Now, what is Goldstein's view? Goldstein thinks that a collaborative contribution will not produce a joint work, and a contributor will not obtain a co-authorship interest unless the contribution represents original expression that could stand on its own as the subject matter of copyright. So please note that in case of a collaborative contribution, that will not produce a joint work, and collaborator cannot be called to be a co-author until and unless contribution represents original expression that could stand on its own as the subject matter of copyright. So if you have corrected spelling, whether the corrected spelling itself can make you an author. If you have corrected punctuation, whether corrected punctuation can make you an author. If you have given your review, those reviews can independently make you an author. So according to Goldstein, the use of word author in the section implies that the contributors of each must be a copyrightable work of authors. That means each and every contributor in a joint work must contribute in such a way that each of them will stand independently as author. Niemeyer points out that neither the Copyright Act of 1976 nor the legislative history of the Act provides support for the proposition that an author must make a copyrightable contribution. That you must make a contribution, but whether your contribution has to be copyrightable or not, that reference is neither there in the Act nor in the history. He points out to the definition of joint work in Section 101 of 1976 Act, which contains no separate requirement that each putative collaborator contribute something that can stand alone as being independently copyrightable. So the question is that whether you have contributed or not. So one might contribute by correcting spelling, one might contribute by correcting punctuation, one might contribute by making the structure useful. By one can contribute by giving comment. Ultimately, all of them have given their contribution. Whether those contributions are independently copyrightable or not, that's not the question. Congress made the intention as the touchstone of joint authorship status, while saying nothing of a copyrightable contribution requirement. So what is important is that whether those five people had they have the intention to be a joint author or to create a joint work, not that whether independent contributions were copyrightable or not. You can identify two conditions. One, each of the parties contribute an independently copyrightable contribution, or whether the parties intended to be joint authorship when they are working as their respective contribution. Now, if you put these two conditions as a touchstone and try to create a jurisprudence, or should they be independent, that is either or? Is it that whether they independently created a copyrightable contribution, or whether they had the intention to be a joint author? So if I ask for assistance from five people to do five different work for any consideration, obviously there was no intention to become joint author. I was looking for a support, they have provided me the support, I have offered them some consideration. That's it. There was no intention to be joint author. So the question is that whether that intention to be joint author is important, or whether their contribution to create an independently copyrightable work is important, is something which you need to find out. InfoPack from EU hits a very interesting situation. In InfoPack, they have said copyright only applies to original work, and that originality must reflect author's own intellectual creation. So what is important is that whether author's own intellectual creation is identified, then only you can be considered as author. That is usually understood as meaning that an original work must reflect author's personality, which clearly means that a human author is necessary for a copyright work to exist. So if you look at InfoPack's contribution or indication, then it's very clear that author's own intellectual creation is necessary. The reflection of author's personality is necessary. And that's why there has to be an human author. Nothing but a human author is required to become an author. In that case, the question will come that what about computer generated work? If you look at CDPA in UK, computer generated work is, in case of literary, dramatic, musical, artistic work, which is computer generated, the author shall be to be taken to be the person by whom the arrangement necessary for the creation of the work are undertaken. That means the person who has taken the initiative, the person who has taken that necessary steps to create the work. Furthermore, 178 of CDPA defines computer generated work as that is generated by computer in the circumstances such there is no human author of the work. So you need to differentiate from computer generated work from computer assisted work. So when I'm writing an article, I can always take help of Grammarly to check the spelling. But that's not computer generated work, that's computer assisted work. But suppose there is a software where there are already certain diagram has been fixed, and you select one of the diagram and then the diagram is created. Here you do not have any contribution, you have only just given a command. That artistic work, the diagram has already been created. That's a computer generated work, not computer assisted work. Now if you look at the recent version of AI generated work, in case of AI generated work, in China, Sengen Townsend created an AI developed writing assistant called Dreamwriter. And it published an article which is written by this Dreamwriter. And it was very clearly notified that the article was automatically written by the Dreamwriter. After it is being published, the defendant reprinted it without permission, which in a normal situation will be a copyright infringement. And the plaintiff sued the defendant for copyright infringement. Court ruled in favor of infringement, deciding that the article is owned by the plaintiff and there has been a copyright infringement. Court found that the work generated by the Dreamwriter had creative input of the plaintiff, that copyright protected work, that requires the copyright protected work. So if that is the case, then AI generated work should be treated as computer generated works, should be treated as copyrightable work, and the infringement and all other application of copyright law should be done in the same way. But in the Indian scenario, for Indian Copyright Office, the Raghav, that is AI generated author, came in, came out, and we do not know what is the status. Because when there was an application by Raghav as the sole author, it rejected because there is no human author, it is AI. When there was another application by a natural person along with AI, they are named as co-author. Copyright Office granted registration and then again send the withdrawal notice. So Indian copyright law or Copyright Office is still not very clear how to proceed with the AI generated work. Ultimately, possibly any authorship debate in AI generated work, I think we need to emphasize or discuss only this point, that whether you think author should be a human author. If you think that author has to be a human author, then that is one side of the story. If you think that author can be anyone, whether human or computer or AI, then you have another direction. And I'm sure these two roads are not going to meet ever. Possibly they will run parallelly next to each other. We have to wait and see how the jurisprudence of authorship unveils in the course of development of AI and AI generated work. Thank you. Thank you very much. Questions?
Thank you so much, sir, for your informative lecture. I would like any attendees, if there is any question, just put it in the chat box.
ChatGPT. That's an interesting question. That's an interesting question. No, but the question before that, because your question was whether there is an infringement. But to address that, you need to ask a question that whether a work created by ChatGPT is copyrightable. If yes, who has the copyright? Whether you consider ChatGPT as author or it is joint author, what will be the status? Then once you address that, and if your answer is yes, then anyone who reproduces a work created by ChatGPT without permission is an infringement, until and unless it is protected by fair use. So the second part is little clear, provided you are clear about the first question. So if you are clear about your first question, that whether work created by ChatGPT is copyrightable, and if the answer is yes, and if you think that ChatGPT is the author and thereby the owner of copyright, then anyone who reproduces ChatGPT's production or creation without permission is infringement, so long they do not have protection of fair use. Clear?
Thank you, sir. Now I invite Professor Sonika Nair, Coordinator of CMR University KCST IP Cell, to propose vote of thanks.
Thank you, Harshita. Am I audible? Gratitude is not only the greatest of virtue, but the parent of all the others. Respected guest of honor, Professor Dr. Anirban Majumdar, Dr. T.R. Subramania, Dean, School of Legal Studies, CMR, Dr. V.J. Praneshwaran, Director, School of Legal Studies, CMR, faculty, and students. A very good afternoon to everyone who is attending this webinar. It is such an honor for our institution to host this wonderful event. On behalf of KCST IPCL SOLS, I take this opportunity to propose a vote of thanks. At the outset, I extend my heartfelt gratitude to our esteemed guest, Dr. Majumdar, and we are enlightened with your knowledge, sir. And I would also like to thank our Honorable Dean, Professor Dr. T.R. Subramania, and Director, Dr. V.J. Praneshwaran, for their constant support. I would also like to extend thanks to my colleagues and student coordinators for their constant support and their efforts that they had put in. Thank you so much.
Thank you.
Thank you. Thank you so much.
Thank
Thank you, sir.
Have a great day ahead.
Thank you. Thank you. Namaste.